Hello and welcome to Fiddling with Trademarks with experienced attorney Travis Richins. My name is Kevin Rosenquist, and I appreciate you being here as we talk more about trademark law. Travis, great to see you. Thanks for being here.
Nice to see you again, Kevin. How are you?
I'm doing great, and I'm excited to talk more about this. This is a real fascinating subject for me, and something that you brought up in previous episodes. We're going to dive a little deeper into it, and that's something called likelihood of confusion. Can you kind of just explain what that means in the scope of trademarks?
Sure. So it's helpful to think first about what trademarks are for. And we talked about this before, but just since this is a new episode, I'll explain what a trademark is. So a trademark, your most common examples are names of companies or names of products or logos that are designed to help consumers associate that good or service with that product. So like, I know we were just looking at my like invisible thermo flask, wondering, okay, what's the, are they, so I look at that and I know, okay, this is coming from that company, right? So that's what a trademark is. And then likelihood of confusion is the most common reason that trademarks are rejected by the trademark office. And it's basically just saying, we think your name is too similar to somebody else's name, or your catchphrase or your logo. It's too similar to somebody else's, and people are going to think that it's coming from that other source. So there was a case, and I don't want to go into the details, but a company started selling products under 3N, as in Nancy. And you might be familiar with 3M, as in Mary, if you use Scotch tape or Post-its. And so that's the kind of thing you're looking for is, well, will somebody think 3N is too similar to 3M? And the answer is yes.
Yeah.
And it doesn't have to be in trademark world. They don't have to be twins. They just have to be close enough, right? So I mentioned this in both the previous episodes. You can't just fiddle with the mark in order to fix the likelihood of confusion. If it's similar and a consumer would think that the source of the good or the service is, they're confusing it with some other company, then you're going to have a likelihood of confusion. The DuPont case, and it set out like a list of 13, I think it was 13 factors. The trademark office looks at the first 4. And so they look at these, I don't know a better word than factors. It's a legal word, I'm sorry, but they look at these 4 factors and they say, the first one is the similarity of the marks. The second is the similarity of the goods or services. Those are the 2 that like govern most cases. So in most of my conversations with potential trademark clients, we're talking about those 2 factors. And that's pretty intuitive on its face. It's like, well, okay, does my mark sound like theirs? Does it look like theirs? But there are examples of like identical marks that both got registration because they're in entirely different like fields, right? They provide very different goods or services. So that's the second factor is how similar are the goods and services. And if you're both selling shoes, you have similar marks and you're both selling shoes, then you're going to get a likelihood of confusion rejection. If you're similar marks and one of you is selling clothing and, the other one is selling like what's going to be outside class 25, like
car parts.
Sure. Yeah. Car parts. I'm trying to think of something close, but yeah, say it's car parts. Fine. Right. Then you might get away with it if they're similar though. Right. And when we talked about this too, there's 45 international classes of goods and services, international classes. So, and the trademark office will follow those. Any good or service that you provide as a company will fall within one of those. If your mark is similar to somebody else and you're in different classes, then you might avoid a likelihood of confusion rejection, but they don't have to be even identical classes, right? So if it's a big brand, like you had mentioned Nike before, if it's a big brand like Nike, then they're going to have that Nike mark protected in many different classes. And their consumers are used to thinking like that something kind of close to it, they might move into another class. And if a consumer would think that you would move into that class, then there could still be a likelihood of confusion.
That's interesting. I was going to ask about the way consumers perceive a brand. And that's an interesting point. Like, I didn't think about that. Like, it makes sense for Nike to move into, different types of apparel or a sport or something. So like, but if Nike moved into car parts, you'd be like, that's an interesting pivot,
That's
you know.
weird. But if it's
so like
basketballs or footballs,
Yeah, exactly. So when they consider, when likelihood of confusion is considered, do they think about how consumers might perceive a brand? I mean, that's sort of
Absolutely.
Objective though, right? Or
a little bit. So they use these factors, but the heart of the question is consumer perception.
Right.
That's really the heart of what they're trying to get at. So they'll also look at other factors. They look at are channels of distribution. So where are the consumers going to be? They'll look at the sophistication of the consumers. They'll look at like, is something like a super high-end product that somebody's going to spend a lot of time in like investigating before they purchase it, or are they going to purchase it on a whim? So there are these arguments. And if you're trying to avoid a likelihood of confusion, rejection, you can make those arguments. But I would say like you want to, from the outset, try to keep yourself in the like different marks or different goods. First two factors. You want to win on those. If you're going down the channels of distribution and sophistication of the consumer and that kind of thing, then you're spending a lot of legal fees making arguments trying to distinguish yourself when maybe you could have just had a, like distinguish yourself by your branding and the outset, and you're more likely to lose. It's just harder.
Yeah, that makes sense. And what about when people, when maybe there was a brand or a company that went under, the trademark lapses, there could still be confusion down the road. So does that somehow factor in?
So those are called dead marks. And when you do a trademark search, the search results can pull up dead marks. You can filter it to leave out the dead marks. I'll leave it in for the dead marks. Now, you can't get a likelihood of confusion rejection based on a dead mark. Okay. So the examining attorney is not going to say, you are too similar to this dead mark, so I'm going to refuse your application.
Okay.
That's not going to happen. The reason I look at the dead marks is I want to know what happened to that mark, because maybe they just stopped making the product, but maybe they abandoned it, or maybe it was rejected for a reason that could apply to you.
Good call.
Yeah. So, and that's something like you'd asked in another episode, why get an attorney? Well, another reason is an attorney's going to think, hey, I'm going to look at the dead marks too, to know why is it dead? And does the reason this mark is dead, does that tell me something that my client wants to know? Yeah, it could be, it could be that sometimes what I'll find is somebody applies, the mark's dead. I'll go look and see, were there any TTAB, that's the Trademark Trial and Appeal Board, were there any proceedings there? And sometimes what you'll find is it's like shots over the bow. So somebody will file their application, and there's this publication period where other people can file oppositions, and there's a deadline to file the opposition. The opposition has to be filed in the TTAB, the Trademark Trial and Appeal Board. If you go to the Trademark Trial and Appeal Board, sometimes what I'll find is another company filed a request for an extension to file an opposition, which is, hey, we're not filing an opposition on you, but we just asked for an extension because we're going to. And that hints to the other side, we're going to oppose you. And oftentimes I'll see this request for an extension, and that's it. The extension's granted, and then the other side just abandons it. It never gets fought out in the TTAB. It was just a shot over the bow, and then they said, okay, right? So that's the kind of information you can get from looking at a dead mark, is all this kind of back stuff. There was probably a cease and desist letter sent, but you don't see that in the public record. But there are hints in the public record that there might have been a little bit of a dispute over it, and somebody came in and said, nuh-uh, and that's why they backed off.
That's a good point. Like, about why to get an attorney, just because like, those little tricks.
Yeah. The little games that are going on in the background, these little hints that you can look up.
How do the ways products are marketed or sold influence whether a trademark might confuse people?
So that's when I'm talking about channels of trade.
Oh, okay.
Right? So if the product would commonly, but like there's some old cases and maybe some new ones, but like they seem a little antiquated now, but like, the case is talking about, would you find these in the same department store, in the same aisle, or that sort of thing? So if they're marketed, so say that there's two products, they have similar marks, maybe not identical. They're similar goods, but not identical, but you would find them on the, like ties, you would find on the same, like in the same part of the department store as men's slacks, or as belts, or, those kind of things. Or, you might find women's hosiery in the same, like somewhere close to where you'd find men's ties. Then if they're marketed in similar channels, they're marketed to similar consumer bases, they're sold in similar places, then all of that can factor into, hey, there's a likelihood of confusion between these two marks.
I think I've heard you talk before about strength of a brand or trademark. How does that play in preventing confusion?
So when I say, and strength is kind of loose. So sometimes I mean like a brand that is very well known. It's really famous.
We said Nike earlier.
Nike is an example.
Yeah.
And they've got marks. If you looked it up, they've got marks in a lot of different classes. They're going to get more deference. And it makes sense why, right? That a consumer is more likely to assume that a company like that is going to expand their products or services into other classes than a smaller, less famous brand that is doing one thing and one thing only, right? Like it's a company that, you know, a ma pa shop that sells salsa. Maybe they've broken into a few grocery stores, something like that, but they're not known for other products. So if you have a market that's maybe similar to theirs and you're, you know, selling tortillas, now that's close, right?
Right.
Like maybe the small company is going to get protection for something like that. And they're likely in the same class, but they're, you know, less likely like to go into like, oh, it's clothes. Like you're selling clothes under a market that's similar to some mom and pop shop that does salsa, then, you know, consumers are less likely to associate those things or think, oh, this, you know, these slacks must be sold by the same people who made the salsa.
Wow, I can't believe I'm buying pants that are exactly the same company. Yeah. My favorite salsa.
Yeah. So the fame of the mark can help. The strength. There's also, you know, a stage at which a mark becomes incontestable. It's not totally incontestable, but it's called incontestable. There's still, you know, ways that it could be attacked. But so a mark can be strong too, because it's become incontestable. It can be stronger because, you know, like we talked about a famous company. It can be strong because it's arbitrary or fanciful. All of those things lend into the strength of the mark.
How can businesses avoid trademark confusion? If someone's launching a new product, a new service, or new business, what is your advice for the best way to avoid basically what we're talking about?
Like a likelihood of confusion is to run a comprehensive search. That's the simple answer. Hire an attorney, run a comprehensive search. The likelihood of confusion comes up when you file your application. Once the trademark office picks it up, an examining attorney will pick it up. They will do a comprehensive search to decide if they think that there's a likelihood of confusion. So the best thing to do is to replicate that process on the front end. Like, you know, start with the end in mind mindset and do the comprehensive search, look at everything that's out there, be really broad in that. And that way you're not going to be surprised about what else is out there. And then there's the sort of be open to the idea that in early stages, maybe you need to make a change.
Well,
that's hard news. Yeah. And it's a business decision. Sometimes I've had businesses say, no, let's risk it. You know, I say, this is a high risk mark. And they say, you know, well, we're going to apply for this, but there's like some good chances of a likelihood of confusion, rejection. But they're really attached to the name. They like it and they want to try, and you can go for it. And that's fine. That's a business decision. At that point, you're just identifying your risk tolerance like you would in like an investment or something.
Well, I think it was the last episode or this one, I can't remember, but you said it's like an 8-month wait right now. I mean, that's a big risk. Almost a year to wait to see if you get it or not.
Yeah. Now, entrepreneurs, though, they're risk takers, right? And lawyers tend to be risk averse. You're paid to be risk averse. And they're like, thank you. Appreciate you pointing out the risks. You know, but entrepreneurs are by nature, you know, if they weren't risk takers, then they'd go get a 9-to-5.
That's true. That's really, really true. Does the person, like who you get as the person looking at your trademark application, matter? I know there's factors, but at the same time, like some of it's a little bit subjective, right?
Yeah, there's some subjectivity in there, and you can get, so definitely the experience of the examiner, how much experience they have, what are their kind of some opinions, because there's
what mood are they in?
Yeah, what time of day do they pick up your
is it Friday? Is it Monday?
And you have zero control over who picks it up, or like typically, right? Like who picks it up, or, you know, and of course what time of day. And
yeah, totally. Yeah, that's luck of the draw right there. Is there any consideration for where your business operates when it comes to confusion? Does that factor in at all?
Typically, no. Like generally, the answer is no. And the reason now, like if it gets into, you know, channels, then maybe. But they're looking at usually federally registered marks, which means like if you have a federally registered mark, even if you're only in a few states, your federal mark protects you nationwide.
Okay.
That's the reason you want a federal mark. Like if you can qualify for a federal mark, you want to qualify for a federal mark, because then you're basically dibsing use of that name or logo in connection with that kind of good or service throughout the country. Right.
Okay.
So it's not going to, now, if it's like a common law conflict, then maybe the geography can matter. But most rejections are going to be looking at like a registered mark.
Okay. So they don't think about like if I've got a business in Washington, there's another one in Florida, but neither of us go outside of it, but they're similar. Will they take that into consideration? Like,
well, in your hypothetical here is, let's say the Florida one is first in use. Okay. Do they have a federal mark registered, or are we?
Yeah, let's say they have a federal mark registered, but they haven't ever left Florida.
So, well, if they've never left Florida, they might have a difficulty getting a federal mark. They have to have some sort of interstate commerce to get a federal mark. Now, that could be, depending on the product, they could be shipping to customers outside Florida. They could have customers from outside Florida coming in. So, okay, let's assume they're in Florida and they legitimately got a registered federal trademark. Then they're protected throughout, and I forgot the other state you mentioned, but they're protected. Matter. Yeah, they're protected throughout the U.S. So it will not matter that they are based in Florida and the other one is, say, Washington State, right? It doesn't matter that they're on the other side, opposite sides of the country, if that Florida, entity has a federally registered trademark.
Okay. All right. Yeah. I wasn't sure if that was like, because of that vast distance. I did use Washington as the example, by the way.
You did. Okay. Good job. Good job. Let's take them like this.
Right.
So, and here's the, but that goes back to the example a couple of episodes ago when we talked, where I had this client that they were in the West, and their attorney was aware of this company that was in the East. I don't know if they looked to see if there was a mark, but they said, "Oh, they're in the East and you're in the West. We're good." Right. And you're a local, you're a local business and you're not planning on expanding or franchising outside the state. You should be okay. And that East Coast business crept across one is they had a federal mark. So if our West Coast company had applied for a federal mark at that time, they would have got rejected. They would have got a likelihood of confusion rejection. They didn't apply for a mark, and that East Coast company spread across the U.S., has expanded into the West state where, my client was, and then you've got an infringement on your hands.
Right. Yeah. All right. Well, thank you very much for joining us here on Fiddling with Trademarks with experienced attorney Travis Richins. If you'd like to connect with Travis, he is on LinkedIn. He is active on LinkedIn. He also has a website, richinslawfirm.com. And don't forget to like and subscribe to our channel. We'd love to have you here. Travis, thanks so much. It's always great to see you.
Thanks for having me.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.